Welcome to NYPTI's Decisions on the Go, using AI for over a decade to help you listen to New York State Court of Appeals decisions on the go. After the podcast, visit www.nypti.com/law to read the full decision.
People v. Omar Johnson, decided on November 24, 2025. Halligan, J. The defendant in this appeal was convicted of attempted criminal possession of a weapon in the second degree, Penal Law 265.033. A firearm license would have given the defendant a defense to that charge. He contends that the U.S. Supreme Court's decision in New York State Rifle and Pistol Association, Inc. v. Bruen, renders the state's entire firearm licensing scheme facially unconstitutional, and thus his conviction should be reversed. We hold that although the defendant waived his right to appeal as part of a plea bargain, his facial constitutional challenge nonetheless. The defendant was directly affected by his criminal prosecution and conviction, and we conclude that he therefore has standing to challenge the licensing scheme even though he did not apply for a firearm license. But his claim fails on the merits. Before the trial court, the defendant argued only that Bruen's invalidation of the licensing scheme's proper cause requirement rendered the state's entire licensing scheme unconstitutional. That requirement is severable from the rest of the licensing scheme under New York law, and the defendant has not shown that there is no set of circumstances in which the licensing scheme would be valid. We therefore affirm. 1. On July 30, 2022, police were called to defendant Omar Johnson's home in response to a 911 call reporting that he had hit his domestic partner. While investigating the incident, an officer discovered a loaded 9mm pistol in the defendant's moped parked on the street in front of his home. After ascertaining that the defendant did not have a valid license for the pistol, the officer arrested the defendant, and he was indicted for various counts of criminal weapon possession and possession of ammunition. These events occurred shortly after the U.S. Supreme Court decided Bruen on June 23, 2022, and before the amendments to the state's firearm licensing scheme went into effect on September 1, 2022. The defendant moved to dismiss the indictment. Rather than attacking any specific provisions of the licensing scheme, he argued broadly that Bruen effectively struck down New York's public carry licensing system by invalidating the proper cause requirement. The defendant further contended that because the charges against him rested solely on the basis that he did not obtain a license to carry a firearm, the indictment could not stand. Supreme Court denied the motion. The court held that the defendant lacked standing to challenge New York's gun licensing laws because he had not applied for a license and could not show that it would have been futile for him to do so. The court also rejected his claim on the merits, concluding that Bruen had invalidated only the proper cause requirement and did not render the entire licensing statute unconstitutional. The defendant subsequently pleaded guilty to attempted criminal possession of a weapon in the second degree and was sentenced to 5 years of probation. As part of his plea agreement, the defendant waived his right to appeal. On appeal, the defendant renewed his argument that Bruen invalidated the state's entire firearm licensing scheme, notwithstanding his waiver. He argued that a Bruen claim cannot be waived because it relates to a right of constitutional dimension going to the very heart of the process, quoting People v. Benjamin. He also argued in the alternative that the waiver was not knowing and voluntary. On the merits, he continued to assert that Bruin's invalidation of the proper cause requirement rendered the entire licensing scheme unconstitutional, and also challenged for the first time several other provisions of the then extant licensing scheme, such as the good moral character requirement, the requirement that an applicant be 21 years old, and the prohibition on possession by convicted felons. The appellate division affirmed. The court held that the defendant's appeal waiver was valid and foreclosed review of his Bruin claim. Alternatively, the court held that the defendant lacked standing to challenge the licensing scheme because he had not applied for a license, and that his conviction was not unconstitutional under Bruin. A judge of this court granted leave to appeal. 2. We must first determine whether the defendant's facial constitutional challenge survives the waiver of his right to appeal. In People v. Seeberg, we held that appeal waivers generally are enforceable if they are knowing, intelligent, and voluntary. We also noted that there are exceptions, though. Claims that transcend the individual concerns of the defendant and implicate society's interest in the integrity of the criminal process cannot be waived on appeal. Seeberg explained why most valid appeal waivers should be upheld. They are typically entered into as part of a plea bargain, which Seeberg describes as a vital part of our criminal justice system. Generally, there is no public policy precluding defendants from waiving their rights to appeal as a condition of a plea and sentence bargain, and holding a defendant to the terms of such a deal serves the public's interest in the final and prompt conclusion of litigation. In furtherance of these interests, we have enforced waivers of various constitutional rights, a point highlighted by the concurrence. Those include the right to appeal Fourth Amendment suppression rulings, see People v. Kemp, Fifth Amendment suppression rulings, People v. Thomas, and double jeopardy claims, see People v. Allen. But each of these types of claims presents a challenge to the legality of a specific proceeding concerning a particular defendant, akin to an as-applied constitutional challenge rather than a broad claim that a statute was facially invalid. On the other hand, we have held unenforceable waivers that transcend the individual concerns of the defendant and embrace the reality of fairness in the process itself. Seeberg, see also People v. Mniz, waivers implicating a public policy consideration that transcends the individual concerns of a particular defendant to obtain appellate review cannot be enforced. One example we gave in Seeberg was a constitutional speedy trial claim. That claim cannot be waived on appeal because it implicates a societal interest in providing a speedy trial which exists separate from and at times in opposition to the interests of the accused, People v. Blakely. Another example was a challenge to the illegality of a sentence, Seeberg, citing People v. Francabandera, which implicates a court's authority to sentence a defendant. Since Seeberg, we have also held that matters going to the jurisdiction of the court may not be waived, Thomas. We hold that a facial constitutional challenge, such as the one presented here, likewise falls into the narrow class of non-waivable appellate claims. Hornbook law underscores the very high bar for this type of challenge. A litigant must contend that, in any degree and in every conceivable application, the law suffers wholesale constitutional impairment, Cohen v. State. In the rare circumstances where a facial challenge is successful, the law is invalid in toto and therefore incapable of any valid application, People v. Stewart, and thus the state will lack authority to prosecute or punish the defendant or anyone else for the conduct at issue. In that key respect, a facial challenge goes squarely to the fairness in the process itself, Seeberg, and transcends an individual defendant's concerns to implicate a larger societal interest in its correct resolution, People v. Callahan. Accordingly, a waiver that precludes appellate review of a facial constitutional challenge to a criminal statute should not be enforced. The appellate division's contrary view rested on the erroneous premise that the same standard governs whether an issue is waivable on appeal and whether preservation is required. Noting that this court had already determined that Bruen claims must be preserved, the appellate division concluded that they also can be waived on appeal, citing People v. David. That approach improperly conflates the standards for preservation and waiver. The two inquiries present distinct considerations. Preservation implicates constitutional limitations on this court's jurisdiction, People v. Turriago. Critically, preservation also allows for the development of a record that would allow for careful and deliberate adjudication on the merits of constitutional challenges presented to us, People v. Cabrera. Appeal waivers, by comparison, serve the important interests of prompt resolution, conservation of resources, and finality in litigation, see generally Seeberg. But they do not implicate this court's jurisdiction. Nor does adjudicating an appeal despite a waiver impede the development of a record, which is a key distinction between the two doctrines. Because preservation and waiver serve different purposes, our prior determination that Bruen claims must be preserved does not resolve whether they can be waived on appeal. Nor are we persuaded by the People's suggestion at argument, echoed by the Attorney General, that we might decline to enforce an appeal waiver if there is a glaring constitutional issue, but otherwise enforce them. That approach would invert the analysis. If the enforceability of an appeal waiver turned on the strength of a constitutional challenge, a court would always have to peek at the merits before deciding whether to proceed, thereby defeating the point of the waiver. Moreover, any discomfort with enforcing an appeal waiver that prevents a defendant from challenging a patently unconstitutional statute proves the point, for it undoubtedly rests on a well-placed concern about prosecuting and punishing someone for violating a law that, by definition, is impermissible in each and every one of its applications. The concurrence opines that our holding today will increase the burden on courts and litigants. But, as with any claim, a facial constitutional challenge must be preserved in the trial court. See Cabrera. Additionally, our precedent leaves no doubt that such a challenge faces an extraordinary burden of proving that the challenged provision suffers wholesale constitutional impairment to prevail. Owner-Operator Independent Drivers Association, Inc. v. New York State Department of Transportation, and we assume that, consistent with their obligations to the court, attorneys will only bring such claims if they have a non-frivolous basis for meeting this rigorous standard. Nor is it clear that enforcing appeal waivers would always lighten the workload. A brief review of recent appellate division cases reveals numerous instances in which the court upheld an appeal waiver but proceeded anyway to resolve a constitutional claim on the merits. See e.g. People v. Liriano, People v. Williams, People v. Hines. And permitting appellate review of fully preserved facial constitutional challenges should promote judicial economy by ensuring prompt resolution of viable challenges to criminal prosecutions under a particular statute. In sum, we conclude that the defendant's facial constitutional challenge to the state's firearm licensing scheme is not waivable and therefore survives his appeal waiver. We stress that the class of claims accepted from the general rule enforcing appeal waivers remains narrow. There will be few types of claims that transcend a defendant's individual interests and implicate a larger societal value to such an extent that they cannot be waived, and appeal waivers otherwise should be enforced. Because we hold that the claim here is not waivable, we need not address the defendant's alternative contention that his appeal waiver was not knowing and voluntary. 3. Next, we turn to the defendant's standing to challenge the facial constitutionality of the state's firearm licensing scheme. Both the people and the Attorney General argue that the defendant lacks standing to challenge the constitutionality of the licensing scheme because he never applied for a firearm license. Although the briefs before us focus exclusively on federal standing doctrine, we note that federal and state standing doctrines are distinct. See Society of Plastics Industry v. County of Suffolk. The federal constitutional requirement of a case or controversy has no analog in the state constitution. ID, and although someone challenging government action must demonstrate an injury in fact that falls within the zone of interests or concerns sought to be promoted or protected by the statutory provision, Stevens v. New York State Division of Criminal Justice Services, we do not appear to have explicitly embraced the federal requirement of traceability. See Lujan v. Defenders of Wildlife. Here, the defendant has undoubtedly suffered a cognizable injury. Given his prosecution and conviction for unlicensed gun possession, he has an actual legal stake in the matter being adjudicated and has suffered a harm that is sufficiently concrete and particularized to warrant judicial intervention. Stevens. The defendant's injury is also within the zone of interests sought to be promoted or protected by the statutory provision. Although the text of Penal Law 265.03(3) does not reference unlicensed possession of a firearm, a defendant may avoid prosecution under that provision by producing a valid firearm license. See Penal Law 265.20 A3. David. Thus, as this court has recognized, New York's criminal weapon possession laws prohibit only unlicensed possession of handguns, People v. Hughes. And here, the only basis for the defendant's conviction was that he possessed a gun without a license. Guidance from the U.S. Supreme Court instructing that a defendant need not comply with what he alleges is an unconstitutional licensing scheme to challenge a criminal conviction reinforces our conclusion. For example, in Staub v. City of Baxley, a defendant was prosecuted for soliciting union membership without obtaining a permit. The court held that the failure to apply for a license under an ordinance which on its face violates the Constitution does not preclude review of a judgment of conviction under such an ordinance. Similarly, in Shuttlesworth v. City of Birmingham, the defendant was prosecuted for participating in a civil rights march because he failed to comply with a city ordinance requiring a permit for all public demonstrations. Again, the court held that a person criminally prosecuted for violating a licensing law need not apply for a license in order to attack its constitutionality. The facts here are essentially indistinguishable in all but two respects. First, the defendant asserts a right under the Second Amendment rather than the First Amendment. But the Supreme Court made clear in Bruen that the Second Amendment is not a second-class right subject to an entirely different body of rules than the other Bill of Rights guarantees. Bruen, quoting McDonald v. City of Chicago. Second, a valid firearm license is a defense to a criminal prosecution rather than an element of the offense. But the legislature's decision to structure the penal law in this manner cannot shield the licensing regime from a facial constitutional challenge. The fact remains that the defendant was prosecuted only because he possessed a gun without a license, and he alleges that the state's gun licensing scheme is facially unconstitutional. The Attorney General attempts to distinguish Staub and Shuttlesworth by suggesting that the licensing schemes at issue in those cases were obviously void on their face. But that judgment entails consideration of the merits of a facial constitutional challenge. Because this would put the proverbial cart before the horse, it provides an inapt ground for parceling out standing. The people and the Attorney General further argue that United States v. DeCastro requires a different result. DeCastro rested on federal concepts of standing, which do not bind us, as noted. In any event, DeCastro presented different circumstances. The defendant there was prosecuted for violating a federal law that prohibits transporting a firearm purchased in one state to another, and he argued that New York's gun licensing scheme effectively compelled him to leave the state to purchase a gun and then carry it back across state lines. The Second Circuit held that he lacked standing to challenge the constitutionality of the state's gun licensing scheme because he failed to apply for a license. As the Second Circuit has since explained, DeCastro had limited reach. The circuit clarified that DeCastro was really about traceability, see Antoniuk v. James. That is, there was no way to know whether the New York licensing scheme itself caused the defendant to buy a gun elsewhere and transport it across state lines, and thus the causal chain between his criminal conviction and the licensing scheme was too tenuous. Here, by contrast, the defendant's conviction is directly traceable to the state's licensing scheme. The circuit also said that DeCastro governs only challenges to a licensing rule regarding eligibility. Where a defendant's claim is rooted in personal ineligibility to obtain a firearm license, the court explained, it makes sense to require the defendant to first attempt to obtain a license in order to challenge the eligibility rules. But when a defendant challenges the licensing application process itself, as in Antoniuk, the failure to apply for a license is not a barrier to standing. The facts of this case resemble Antoniuk, not DeCastro. The defendant challenges the facial constitutionality of the entire licensing scheme, not an eligibility rule. We conclude that the defendant has standing to challenge the constitutionality of the state's firearm licensing scheme, notwithstanding his failure to apply for a license. On this point, we are aligned with sister courts in Massachusetts and California. See Commonwealth v. Rodriguez, People v. Bay, but see State v. Ortiz, finding defendant did not have standing to challenge licensing statutes. 4. Turning to the merits of the defendant's Second Amendment challenge, it is essential to spell out precisely the question before us. That turns, as always, on what arguments were made with sufficient specificity in the trial court. People v. Robinson. See also People v. Baumann and Sons, Buses, Inc., applying same rule to a constitutional challenge. We are able to discern from the defendant's motion papers only one claim made with the requisite specificity: that Bruin's invalidation of the proper cause requirement rendered New York's entire firearm licensing scheme facially unconstitutional. Bruin presented a challenge to one discrete aspect of New York's firearm licensing scheme, the proper cause requirement. The court's analysis and holding was confined to that provision and did not address any other aspect of New York's licensing scheme, see Bruin. To the contrary, Bruin instructed that states are not prohibited from imposing licensing requirements on persons who wish to carry a gun for self-defense. The court observed that Second Amendment rights are subject to well-defined restrictions and expressed approval for the gun licensing regimes of 43 states with shall-issue licensing regimes, which often require applicants to undergo a background check or pass a firearm safety course. Bruin. Several concurrences made similar points. Kavanaugh, J., concurring, noting that the Second Amendment allows a variety of gun regulations, including prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places. Alito, J., concurring, stressing that the court's holding decides nothing about who may lawfully possess a firearm or the requirements that must be met to buy a gun. Whether the proper cause requirement infected the rest of the licensing scheme so as to render it unconstitutional in its entirety raises a question of severability. To answer it, we look to legislative intent. Whether the legislature, if partial invalidity had been foreseen, would have wished the statute to be enforced with the invalid part extended or rejected altogether. CWM Chemical Services, LLC v. Roth, quoting People ex rel. Alpha Portland Cement Co. v. Knapp. We find the proper cause requirement severable. The text and structure of the licensing scheme evince a clear legislative intent to regulate the lawful purchase, possession, and use of firearms. The licensing scheme is detailed and multifaceted. The proper cause provision was just one aspect of a much broader scheme that includes a variety of distinct requirements. For example, a separate provision sets forth various eligibility criteria to obtain a license, including that the applicant be over 21 years of age, of good moral character, not a convicted felon, and not an unlawful user of a controlled substance. See Penal Law 400.001. Another provision sets forth the types of licenses that an applicant may obtain. See Penal Law 400.002. Other provisions set forth the procedures for applying and reviewing gun license applications. See Penal Law 400.2 through 5. We find it implausible that the legislature would have intended for all of these other provisions to be invalidated simply because the proper cause requirement was deemed unenforceable. The structure of the licensing scheme points to another reason why the defendant's facial challenge fails. The party making a facial challenge must establish that a law is unconstitutional in every possible application. See Supra at 6. It is the most difficult challenge to mount successfully because it requires a defendant to establish that no set of circumstances exists under which the challenged statute would be valid. United States v. Rahimi. The defendant has failed to show that there is no set of circumstances in which the licensing scheme would be constitutionally valid. To take one example, the statute prohibits gun possession by convicted felons. See Penal Law 400.001. The defendant makes no argument before us that this provision is unconstitutional. Without opining on that question, we note that the Supreme Court has made clear that the Second Amendment permits the disarmament of individuals who pose a credible threat to the physical safety of others. Rahimi. See also United States v. Duarte, upholding the federal statute prohibiting firearm possession by convicted felons against a Second Amendment challenge. Vincent v. Bondi, United States v. Hunn. With these principles in mind, we are confident that the legislature would have intended for the rest of the licensing scheme to remain in effect following Bruin's invalidation of the proper cause requirement. Indeed, when the legislature enacted amendments to the licensing scheme following Bruin, it maintained many of the same requirements, providing further evidence that the legislature intended for those provisions to remain in effect. We therefore conclude that the proper cause requirement is severable, and its invalidation did not render the entire licensing scheme unconstitutional. Finally, we reject the defendant's contention that the people were required to provide evidence that the entire licensing scheme is consistent with the nation's historical tradition of firearm regulation. Although Bruin's historical tradition framework would govern challenges to discrete provisions of any gun regulations, see e.g. Antoniuk, the defendant's broad claim before us that Bruin's invalidation of the proper cause requirement effectively rendered the entire licensing scheme unconstitutional does not implicate this inquiry, and the constitutionality of the other provisions of the licensing scheme is not before us. We hold only that Bruin did not render the state's entire gun licensing scheme unconstitutional because the proper cause provision is severable. Accordingly, the order of the appellate division should be affirmed. Order affirmed. Opinion by Judge Hulligan. Chief Judge Wilson and Judges Rivera and Troutman concur. Judge Canataro concurs in result in an opinion, in which Judges Garcia and Singas concur. Decided November 24, 2025.
Welcome to NIPT's Decisions on the Go, using AI for over a decade to help you listen to New York State Court of Appeals decisions on the go. After the podcast, visit www.nipt.com/law to read the full decision.